Professor, you mentioned a letter of indemnity. Now I have a question. In the absence of a letter of indemnity, does that mean the carrier will be, or rather, might be held responsible, especially if a bill of lading was not presented when the delivery of the cargo was taken by the consignee?
That's actually correct, because you are supposed to, as a carrier, perform the obligations of the carriage contracts according to the bill of lading. Of course, there are instances such as when there's a charter party and bill of lading issued together, where the bill of lading is more for receipt purposes, but the bill of lading is always a document of title. It's always telling you who the cargo belongs to, who is the rightful owner. So if the rightful owner has questions about what has happened to cargo, guess who's going to be responsible? The carrier, of course.
The carrier. So I have a follow-up question, which I think it's quite interesting. The responsibility of the carrier to ensure that the goods are released to the rightful owner. Is it codified in the bill of lading, or is it something that is a practice that's a normal practice within the industry, that as a carrier you have a responsibility to ensure that these goods are released to the rightful owner? Or is it one of the naturalias of the bill of lading, as we've explained yesterday?
Yes. So first of all, there is practice. There's well-established practices in the industry where there's certain things that are permitted, which may seem strange to other types of business, but that are permitted in the industries. You spoke of the word naturalia. Yes, you're supposed to naturally follow a certain obligation when you're the carrier to get the goods to the right people, and the bill itself will have all that information that you need. It'll have the agent of the consignee's information. It'll have phone numbers, contacts. It'll even have all the receiving information on the other side where the carrier is taking the cargo to. So there's also established practice around that, long respected practice around that. But practically, there's also issues of a business can go out of business at a crucial time, and so the cargo may not be able to be claimed by anyone once it gets to the port of destination. And so that's when questions of not delaying the ship, because the ship can wait around for the rightful person to come about. So usually that's taken over by another established industry way of saying, okay, fine, find a way for the cargo to have someone issue a letter of indemnity, someone who has a right to issue a letter of indemnity, so that the carrier can continue to discharge the goods rightfully without risking wrongful release to the wrong people. So those are all established practices to make shipping efficient as possible. But of course, the bill of lading should be giving you all that information. In fact, the bill of lading has been termed a document of dignity. It's been termed the lifeblood of the industry. So you cannot just as a go-to disrespect it. And that's what the quota quo in the Primesite case was trying to make a point of, that you must do what you said you would do as a freight forwarder, and that is not risk loss of goods by just randomly releasing to people who have shown no right to them, which is understandable. I mean, the judge was not misdirecting himself or herself when when they made that decision.
Interesting. So I'm just wondering, with regards to ownership, especially considering the facts of this case. The goods have been released to the consignee, which is the Belgium company. this means that they are not the rightful owners because they did not produce the bill of lading. Now, my question is, can we accuse the Belgium company of theft?
You know, Sharon, that's the problem with the payment that is going to be done by a foreign company, and that's why it's practice in the shipping industry that before the seller relinquishes the ownership or relinquishes the goods by transporting them, they will usually get a letter of credit. A letter of credit is a legal document which is backed by the banks to say that the seller will receive their money. So in this case, the Incoterm that was used was cost and freight. So with relation to passage of ownership, the Incoterm determines that. So the Incoterm stands for International Commercial Term, which are these developed contracts by the ICC that give like correct meaning internationally as to what the sales contract between the seller and buyer abroad will agree to. So they'll agree to an Incoterm that suits their needs, because not all buyers want to be involved with the carriage, not all sellers want to be involved with the shipping aspects. So in this case, you would see the ownership passage based on the Incoterm. However, in this case, the main issue is that the Belgian company disappeared with cargo. And, you know, I always overthink these things because I say to myself, before we accuse them of theft, let that case be proved. However, because who knows, maybe they canceled the contract and you never know what really happened. So let the case be proved of theft. But in this case, they were definitely responsible for at least communicating that they no longer wanted the goods. Don't take the goods and not pay if you're not interested in them anymore, you know, or communicate to someone that you can no longer be trusted to pay according to the bill of exchange that you are supposed to sign, that you no longer want to sign for that bill of exchange, but don't take cargo that you're not entitled to. So that definitely there was fault there. And that cargo disappeared.
Just out of interest, how can you prove theft, especially in this case? What would be the things that you look at in order to make out a case for theft?
That's a great question, Sharon. However, in this case, even if you could prove theft, even if the Belgian company was wrong, they are far away. You are in South Africa. How will you enforce that? You know, who will you arrest? Will you call the CEO of the company? What if the CEO has packed his office and disappeared? Will you go pointing out your billboards that you sent out after they've long been used? What if they were sold to several people before they even got used, you know? And what if they were transported to another country without even you knowing? So the seller in this case, Primesite, was correct in actually trying to sue the people they could sue, because both Salviati Santori and Primesite were based in South Africa, so they could deal with each other in terms of enforcing claims. But in terms of trying to put blame and to sue the foreign Belgians, in this case, that there was nothing, you know, that the South African company could do to try and at least, you know, arrest their property or something, or find the responsible person. Yeah, that's the risk you take when you trade abroad. So you have to be aware of these things and try to protect yourself, either by making your payment assured through the letter of credit, or also known as a document to credit, or asking for a direct transfer of cash before release of original bills of lading. And in this case, the payment option was a bill of exchange. And we know with bills of exchange, they are not guaranteed to be paid at some future date. They're like checks, so you never know if a person's going to honor that. And that was the saving grace for the shipping company in the appeal case.
Interesting. So this actually makes so much sense why a bill of lading is so important.
Absolutely.
Because Judge Wallace made an interesting comment, and he said that he did not think that the shipper, and I think the shipper was represented by one of the directors, that he did not think that a person with such business acumen would have allowed for goods to leave without any security for payment. And that's what a bill of lading provided in this case. That if I enter into a bill of lading, I believe that the carrier will not release the goods without the bill of lading being presented to them. And I think that's just one of the comments that he made in order to prove, or rather to come to a conclusion why he believed that the defendant was at fault. And I'll just use that word because I can't think of an appropriate word at the moment, for releasing the goods without being presented with a bill of lading.
That's right. And thanks for reminding me that it was actually Judge Wallace that gave that judgment. So, yes, that's absolutely correct. However, when you trade with foreigners, you can sometimes have a trust for foreigners, and that's fine, and yes, the bill of lading was that security, but in this case there was always risk that the payment may not be made. Even if the Belgians had signed the bill of exchange, there was no guarantee that they would have made the payment. But I don't blame a businessman who maybe even has a history with this company for trusting them and believing that they could get along and not face a scam situation. Sometimes, there is a World Bank directed research body that actually looks at statistics at the most corrupt countries or the most corrupt areas of the world, and they do have that list. And Belgium is not in the top corrupt nations, so you would not expect something like this type of scam to happen. But you cannot also really, I always say trust but verify. Trust by verify. So in this case, there was definitely a trust there which was abused. So you cannot blame people for, hindsight is always 2020, but at least this is a learning opportunity. This case is a learning opportunity for all of us.
Thank you actually for ending with that, because in conclusion I was gonna ask you, what do you think, maybe in 2 sentences, can you tell us what exactly it is that this case is making us aware of, especially for those of us who are, participants in the maritime industry, those who are involved in international trade? What exactly can they take away from the case?
Number one, the bill of lading is so important. Protect it at all costs, but also make sure that you get payment for your cargo that's going to be released. Make that assured before you release the goods. There's so many things I could say about this case. It's one of my favorites, but those are probably the 2 top things at this point in time.
Okay, thank you so much, Professor. This was such an insightful session. I've learned a lot myself, and you know what, I would encourage the listeners as well to go read the case. It's very short, it's not long. I think it's just 8 pages.
Correct. Quite
interesting, very informative, and I love how Judge Wallace wrote the judgment. Anyone can just understand it. So thank you so much for discussing this and giving us, the flesh to the bone and making things much more easier for us to understand. This was just such an amazing session. Thank you so much. I think, we do so well with case studies, and we should look into that more often because they are more personal as well, because it's something that actually happened.
I couldn't agree more. And Sharon, Primesites did not go by the wayside because of this one case. They have been going strong. I actually looked up their profile on LinkedIn. Do follow them. They still do amazing billboards. So yeah, we all just have to keep going.
I'll definitely look at them. Thank you so much for this, Professor. Till we meet again and discuss more interesting topics, I think it's about time for us to say the most interesting line of all.
Get on board.
Get on board and tune in.
Thank you, Sharon.
Thank you. Bye.
Bye. Bye-bye.